All the audience present here, you are requested to keep your mobile phone in either silent mode or in switch off mode. While the judges are on session, please maintain silence. Thank you very much.
Parliamentary language. Number 2, the speakers are requested to come on the dais to speak. When the speaker is speaking and the teammates want to pass on some chips to the speaker, they are requested to intimate me, and I will pass on the chips to the speaker. Now I will request the timekeeper.
So now I'll be explaining the animation for this final round of this segment. Each team will be getting 45 minutes for speaking their arguments and including the rebuttals and surrebuttal rounds. If any of the team is allowed some time, the other team should be allowed the same time.
Yes. The council seeks permission to approach the dais.
Greetings of the day. The council seeks permission to refer the bench collectively as your lordships. If your lordships are, would the lordships like a brief of the facts? May it please the court, the present petition arises from a coercive action taken against the petitioners, a software architect and his company, Neuralink Dynamics, engaged in AI-based banking analytics. Following a bank fraud of 120 crores, the respondents initiated an investigation without naming the petitioners, yet proceeded to conduct a warrantless search, seize digital infrastructure, and compel disclosure of encryption credentials under the threat of detention. Subsequently, forensic reports relied upon by the state are disputed due to inconsistencies in the hash values, metadata stamps, and absence of chain of custody. The petitioners challenge these actions as illegal, arbitrary, and violative of statutory safeguards and constitutional protections. May it please your lordship, I am counsel appearing on behalf of the petitioners Arjun Mehra, a software architect, and Neuralink Dynamic Private Limited, an AI-based data analytics company incorporated in Republic of Australia. With your lordship's kind permission, I shall address issue 1, 2, 5 and 1, 2 and 5 arising in this petition. This case, at its heart, is about whether the state may conduct a warrantless raid on a private technology company, compel disclosure of encryption credentials under threat of detention, forensically clone an entire ecosystem, and further retain it to an indefinite period of time. The petitioners reject this action of the state. With your lordship's permission, the counsel for the petitioner will proceed to issue 1. Whether this Honorable High Court, while exercising its writ jurisdiction under Article 226, is duty-bound to intervene when statutory and constitutional safeguards governing digital investigation are demonstrably diluted, or whether judicial restraint must be practiced. The Council humbly submits that judicial restraint is inapplicable and intervention is necessary, anchored in Puttaswamy and absence of any review mechanism. Furthermore, the court, in this exercise of its extraordinary writ jurisdiction under Article 226, has consistently intervened wherever investigative action of the state should transgress towards constitutional and statutory framework of civil liberties. The present case presents precisely such a situation. No valid statutory authority has been identified for the search. Secondly, no proportionate procedure was followed. Third, no judicial authorization was obtained before forensic cloning. And fourth, the ongoing restraint on petitioner's business operates without any time limit or review mechanisms. Your Lordship, the Supreme Court in Justice Puttaswamy v. Union of India held that procedural guarantees form an integral component of the proportionality test, and the right to privacy is protected not merely against substantive violations but against the absence of adequate institutional mechanisms to check the abuse of state power. The court laid down a four-pronged test. First is legality, a legitimate aim, rational nexus, and proportionality. The CCIT possessed no technical audit, expert opinion, or judicial review in their actions. The resulting paralysis of Neuralink's operation, exposure of third-party data, and the state's acquisition of indefinite access to private digital ecosystem render the intrusion grossly disproportionate to even a serious criminal investigation. In the present case, there is no such mechanism. The forensic process was conducted without independent witnesses. The hash values furnished to the petitioner were found to be discrepant by a duly engaged expert. Third, the metadata reflected activity after the date of seizure. And fourth, there is a broken chain of custody of any material seized. Furthermore, the petitioner...
Why won't there be how can you not justify this under 185 BNSS?
Yes, Your Lordship. While 185 BNSS does allow a warrantless search in case of suspicion, it also requires the state to proceed and give a certification or a list to the magistrate in the due time. That hasn't been followed here. We simply ask the state to comply with the procedure while we agree that warrantless search has been identified under the law in cases. Furthermore, petitioner number 1 was compelled under threat of detention to disclose encryption passphrases, administrator credentials, and access token, rendering such extraction constitutionally impermissible under Article 20, Subclause 3. Such conduct also squarely attracts the protection against testimonial compulsion as recognized in Nandini Satpathy versus B.L. Dani. If your lordships are satisfied, I would proceed to my second issue.
Satisfaction will come later.
Thank you, Your Lordship. Further issue is the Council humbly submits that warrantless search, seizure, forensic cloning, and continued retention are violative of Article 14, 19, and 21. Read with the IT Act 2000. My lords, I now turn to the substantive constitutional question, which is the core of this petition. The submissions in this regard are the illegal seizure of digital device, the constitutional infirmity of forensic cloning, third, the disproportionate and continued retention of the same. I submit that the seizure of digital devices was not conducted in accordance with the procedure prescribed by law. Section 103 of the BNSS requires that upon conclusion of a search, a signed seizure memo be prepared in the presence of independent witnesses and handed over to the person from whom the artifacts are seized. Now, there may be a contention that this might just be a procedural safeguard, but the petitioners disagree, my lord. It is a condition precedent to an investigation due to there being a list of the articles seized. The state cannot reject this list and move forward and then name it under procedural lapse. Furthermore, in Radhakishan versus State of UP, the Supreme Court held that non-compliance with procedural requirements places a higher scrutiny, and in criminal investigation, the standard should always be higher. In the present case, the seizure memo was not furnished to the petitioners on the day of the operation. A type list was provided 3 3 days later through an email. The Supreme Court in State of Punjab versus Baldev Singh held that mandatory procedural safeguards governing seizure are substantive protection of individual liberty and not mere technicalities. My lords, I also draw your attention to the failure to disclose grounds. The CCID officers described their presence as a technical inspection. No written notice was served, no FIR copy was produced, no grounds were communicated either at entry or at seizure. The entire digital infrastructure of the petitioners was taken without being told why, under what authority and on what basis the systems were considered relevant. In D.K. Basu versus State of Bengal, the Supreme Court affirmed that unchecked police power exercised without transparency is paradigm to constitutional arbitrariness, which we also see in Article 14. Third, the Council submits that forensic cloning itself has no express statutory authorization and therefore cannot constitute procedure established by law. Forensic cloning is the creation of a complete, indefinitely replicable mirror image of an entire informational universe. CCID cannot claim the power to seize implicitly carries the power to clone. A seized device can be returned. A cloned image cannot be unreturned. Furthermore, the Council submits that the prolonged retention of seized system violates Article 14 and 21. In the present case, the petitioner's entire digital infrastructure had been seized despite the absence of any formal accusation. We weren't even named in the FIR. Furthermore, there has been no charge sheet has been filed since 2 years. Section 106 of the BNSS requires a police officer who seizes a property to forthwith that report of the seizure to the magistrate having jurisdiction, so judicial oversight may take place.
So under the BNSS, isn't there a provision where you can challenge the illegal search and seizure before the magistrate? Why directly to the High Court under 226?
Yes, Your Lordship, we do have that provision available, but at the same time there has been a stop to our business since 2 years. And we are praying to the court that under the writ of certiorari, the state is requested to stop their proceedings, especially of the evidence collected with procedural lapses. Thus, we are in front of this Honorable High Court. Furthermore, this provision was not complied with. The retention is continued under the sole direction of the investigative agency. In Sundarbai Ambalal Desai versus State of Gujarat, the court said that seizure is a clear entrustment of property to the government servant, thus should be returned at the earliest. It has been 2 years, my lord. The failure to disclose grounds of seizure violated the requirement of transparent state action. The principle that state must disclose to an affected party the basis on which it acts against them is a constitutional imperative. No written notice was served, no FIR copy was produced, and no grounds communicated either at entry or seizure. Furthermore, it attacks the non-arbitrariness doctrine stemming from Article 14. Article 21, on the other hand, demands that not merely a statutory basis, but a procedure that is just, fair, and reasonable should be followed. Where state action involves mass appropriation of a private digital ecosystem, prior judicial authorization is not followed, and the prongs of proportionality are not operational. Even if some seizure of Neuralink own system could be justified, the capture of banking customer data belonging to third party who are not a part to this contract or this fraud is entirely constitutionally not valid. The seizure of customer data violates the privacy rights both of the petitioners as data processors and the data principals whose information has been exposed. Furthermore, in S. Parthasarathy versus
Counsel, let me understand, when you're talking about the criminal procedure and the DPDP, let me understand which would be lex specialis and which would be lex generalis in this particular instant.
Indeed, Your Lordship, the counsel requires 30 seconds to clarify that.
Okay, so let me elaborate a little more. In the sense you mentioned that the enforcement agency's CCID has taken everything. Now, how does the technology work? In the sense, the APIs, if you look into the APIs, they are the gateways, they are the front door through which the technology is entering the back-end services. So if you look into the technology from that perspective, and there is a breach, there is a serious breach to the extent of 120 crores has gone. Now, with that, how would you argue that the scissor would not happen?
Indeed, Your
And then you come to the lex specialis. In this particular incident, since you are an academic, I'm asking an academic question as to lex specialis versus lex generalis in this particular instance.
Indeed, Your Lordship. The API keys are definitely a part of the bigger ecosystem in a digital format. But the petitioners are simply praying to the court that they could have limited their search to a certain system that was connected with the Aurelia First Bank. Furthermore, they also proceeded to clone our entire digital system. There, in an AI layered firm or company, there are certain parts which are given to each. With our contract with Aurelia First Bank, there were certain digital systems that were conducted towards them. There were few others which were conducted towards our other customers. The issue here at hand is that they have proceeded to clone the entire system, disregarding which applies to Aurelia First Bank and which applies to the other customers. As per the lex specialis and lex generalis answer, the council would like to argue that the BNSS, which the entire proceeding was held, was lex generalis, while the DPDP Act, due to the nature of the company, would be lex specialis.
So should I not consider that DPDP is lex specialis as far as the protection of the individual rights are concerned? But the moment a criminal action has happened, criminal interference has happened, then this would become lex specialis. The criminal BNS will be lex specialis. Would you not argue that?
Yes, Your Lordship.
Yeah, and then I go further as to whether there is an exception as far as criminal prosecution is concerned, overriding DPDP. Is there any clause of that sort?
The council is not aware if there is any clause of that sort, but if we look at the DPDP Act.
When I say clause, exception.
Yes, any exception as such. But further on, under the IT Act, which the respondents have relied on, which the state has relied on to further their investigation, there are certain caveats that have to be followed. The petitioners are not contending the state has no right to search. They are merely contesting that the procedure has to be followed and... Yes. Under the case of S. Parthasarthi versus State of Andhra Pradesh, the court held that conjecture is not enough. There must exist a circumstance from which reasonable men would think that there is a link between the crime and the party committing the crime. In State of Punjab versus V.K. Khanna, where the court held that mere allegation without cognate evidence cannot establish the basis for state action against an individual. Furthermore, equality is an antithesis to non-arbitrariness. Any action done by the state that are fundamentally discriminatory are arbitrary, foundational principle articulated in Joginder Kumar versus State of Uttar Pradesh, wherein the Supreme Court held that coercive state action, including detention, compelled attendance, and investigative targeting, must be founded upon specific articulable facts, establishing a rational connection between the suspect and the wrongdoing. Further, I would like to draw your Lordship's attention to the entire procedural lapse. The council would like to argue that if there was an isolated incident that had taken place which had a procedural lapse, we would still have approached the court in a different manner. Here, the entire sequencing of the events is a procedural lapse. Every section we look at, there is a procedural lapse. Somewhere the order was not submitted to the magistrate, somewhere the order was not taken from the magistrate, no seized memo, hash value discrepancy after the repeatedly asking the state that please provide us with the certificate. So this mainly goes against the principles of natural justice. A single isolated incident can be overlooked, but a complete procedural lapse not only fails the evidence, but also the right of the petitioners. Furthermore, in natural justice, we have a right of audi ultram partem. It is not a mere procedural courtesy, but an essential ingredient in just, fair, reasonable procedure. Every person has the right to be heard, and that is why we are in front of the court today. Second, the council submits that the present case, the respondents cannot override procedural safeguards as established. Section 69 and 69B of the IT.
Why did you wait for 2 years and not file a application before the competent criminal court, the High Court, under the other law for quashing?
Yes. Indeed, Your Lordship. First reason I would give here is that our name is not in the FIR. Still, an investigation has proceeded against us. That does not allow us to approach the court under 482 of the CRPC. Apologies on not knowing the BNSS section. Yes. Secondly, for 2 years, we have been in continuous communication to the state. We have repeatedly asked them that please provide us with the certificate, please provide us with any conclusive proof that proves that we are a party to the fraud. They have refused to, and in the public front, they have maintained that the investigation matter is a critical stage. But we keep on receiving coercive summons. If Your Lordship. Yes, Lordship, my fifth issue, I would just quote Sri Krishna Committee Report on Data Protection, which was the foundational policy document for the DPDP Act itself. And that parliamentary oversight and judicial approval be required before every government agency could access personal data on a non-consensual basis. Furthermore, it called for a law to provide for parliamentary oversight and judicial approval of non-consensual access to personal data. And lastly, in PUCL versus Union of India, it has been mandated and several safeguards have laid down, especially for cases like this, which interception orders could only be issued specifically by authorized officers upon recording written statements, and intercepted material must be used only in minimum necessary extent and intrusion, and review committees must assess compliance, all of which constitutes judicial and executive accountability even where prior judicial scrutiny was not mandated. Much obliged, Your Lordship.
Greetings, Your Lordship. I am speaker number 2 on behalf of the respondents. I shall be addressing issues 3 and 4 of the submission and finally the prayer. With Your Lordship's permission, I would like to go forward with the issue 3. Your Lordship, issue 3 deals with the electronic evidence, hash values, chain of custody and testimonial compulsion. Firstly, it is a humble submission of the petitioners that Section 63 is a self-contained code as held by Arjun Pandit Rao Kotar versus Kailash Kushan Rao Gorantyal. Section 63 is a self-contained code for the admission of electronic records. It requires that any computer output tendered in evidence be accompanied by a certificate identifying the record, the device used and the method of production. Additionally, secondary electronic records cannot be admitted without a certificate as held in Anwar PV versus PK Bashir. The petitioners claim that no independent witnesses were present during the imaging process and no hash values, which is the duty of the investigative agencies to produce after the evidence has been seized, as the hash values is the only way to establish in front of the court that
the charge sheet has not been filed. So admissibility of the document in evidence will come only in the trial. So how is this issue relevant in the 226?
Your Lordship, it is relevant under 226 as it goes against a fundamental fact of natural justice. When a procedural, not just a procedural lapse, but a fundamental condition to precedent in this instance has not been followed by the respondents in this case. With that fact, the continued restraint on the petitioner's business and fundamental rights without any proper restrictions or restraints causes us to come before this Honorable High Court.
Fair enough. She had raised a legal issue. I would raise a technical issue. You talked about a hashtag. Now you tell me that why is it important for you that irrespective of the charge sheet has not filed, why is it important for you to go and argue, now that you argue, that they have not gone in for hashtag? Why is it so important? What, from a technological perspective, you tell me.
Your Lordship, from a technological point of view, the second image is copied or is forensically cloned, it generates a specific numerological value, which is the only way to prove to the court that it has not been tainted or altered with. And the cases state that the hash values need to be matching with what is seized at the moment of seizure and produced before the court. And in this instance,
so you mean to say that there can be a tampering?
Yes, Your Lordship. The independent report further, which was followed by the petitioners, showed that the hash values have discrepancies. Further, the metadata values also shows altering after the seizure, which directly goes towards the chain of custody in this process that has happened.
Please proceed. Thank you.
The following submission is independent of the certificate issue. Even if the court were to grant that the certificate was a procedural safeguard and not a precedent condition, the deficiencies in the chain of custody render the evidence unadmissible. The threshold of production of authenticity required by Anwar PV, stipulating that the party tendering electronic evidence must demonstrate the integrity of the record form. It's from the point of its production of its code to the point at which it has been collected. The imaging of Neuralink systems without the petitioner's presence, no independent technical observer was permitted to witness the process. Additionally, employees were not allowed to observe or document what was occurring, and no contemptuous hash values was produced in this incident. Even though the respondents in this instance have the right to conduct a warrantless search under the Section 69 of the IT Act, and though they have the right to collect evidence or clone evidences, it cannot override the fundamental rights or the procedural safeguards that has been set place by the court. In this instance, they had no independent witnesses, and the passwords to access the evidence were coercively brought down from the petitioners under threat of detention, which the petitioners will be arguing that goes to testimonial compulsion in the upcoming issue, and also the fact that the seizure memo was a handwritten memo which was produced internally without any signed witnesses goes to the fact that they have not followed the basic procedure under which they are conducting the seizures. And furthermore, after 3 days of delay, when they have sent an email, they have still not produced till date a signed seizure memo. They have produced a typed list and orally communicated that forensic investigation is ongoing.
What is the problem with the typed memo?
A problem with the typed
statutorily, what is the statutorily what is the problem with the typed memo?
Your Lordship, a typed memo
or a typed inventory.
Yes, Your Lordship. In the statutory requirement is that the second a seizure is completed, a signed seizure memo in front of witnesses is to be given to the petitioners to uphold the integrity of the search. But in this instance, 3 days after the seizure is complete, they have given a typed seizure list. In this,
if I call the author of the inventory list, if I call the author, and on oath, if the author confirms, is there any problem?
Yes, Your Lordship, as the petitioners claim that the process of conducting the seizure.
I go back to the previous question as to statutorily, what is important?
Statutorily,
your argument that it is a typed memo. Why is it a problem? Go back statutorily, and that's it.
A typed memo needs to be followed by a signed declaration by the officer who is seizing the evidence that these are the evidences that has been seized. A typed memo is simply a list of the items which they claim to have taken, but there is no confirmation or statutory.
What's the content that they have taken?
They have taken external hardware. They have cloned the systems completely.
And when you say clone the systems, what do you mean?
They have taken all the they have compulsively made us disclose the administrative access to the API system.
Clone what?
They have
Hardware, I understand. Clone what? How do you clone a hardware? Refer to what?
yes, Your Lordship. Your Lordship, the respondents in this instance have taken, no, but not limited to, laptops, external hard drives, and also have directed us to disclose encryption passphrases, administrative system level.
So they're not hard, they're soft.
They have gone forward to conduct seize both external hardware and soft.
Yeah. So it's not just hardware.
It's not just the hardware. It's
Now
the
come
soft-
back.
Yes, Your Lordship. It's not just the hardware that they have seized. They have also seized soft copies and cloud platforms based on which we work.
Now come back to the inventory. Come back to the inventory question.
Yes, Your Lordship.
As to why do you argue that the typed inventory is not going to work? That's what you have argued.
Yes, Your
Why?
Lordship, but typed inventory is not going to work because they have not just limited the seizure to hardware or hard copies. They have also gone forward to seize soft copies of data.
Can they not seize soft copies? Can they not seize software and processes?
Yes, Your Lordship.
They can do.
They can do, but they need to give a certain declaration or a signed memo that they need.
They have not given the declaration. They will come back and they will get it. Even otherwise, there's a statutory. Anyway, we will please proceed.
Only one question.
Yes.
Can these questions be gone into at this stage under Article 226?
Yes, Your Lordship, at this instance, it can be so because after the seizure has happened, it is on a 2-year extensive delay that they are saying that the evidence is still pertinent and are causing the fundamental rights of the petitioners to be violated. After the seizure has happened, they have cloned all the systems. But after cloning and making a copy of all the systems at the point of seizure, they further claim that they are withholding access to mirrored systems and access to mirrored system on the basis that we can further tamper with them. And that is the reason why they are continuing the restraint on it. But when the copied systems at the point of seizure is already present with the respondents, how can they claim that we can further tamper with the evidence and change the evidence if they are already having the copies of it?
This argument you are basing on the fact that now you should be allowed to go back to your regular business.
Yes, sir.
And all the restraints in use of your system, the system that you use, that should be allowed by the court.
Yes, Your Lordship, that will be my issue 4. If I can complete with my issue 3, I will move forward. Much obliged, Your Lordship. Next, I will be addressing the compelled disclosure of credentials constitutes testimonial compulsion and lack of statutory basis. The Supreme Court in Selvi versus the state of Karnataka established the governing principle. Any technique that compels a person to disclose information from within their mind, externalizing what only exists as a private mental knowledge, falls within the prohibition of Article 20, Clause 3. Your Lordship, what is an encryption passphrase? It exists nowhere in the material world except within the memory or cognitive processions of the person who created it. And further, threatening them with immediate detention when no basis for the inspections that was being conducted was given. Threatening them with detention and further asking them to produce these passphrases and credentials to access the evidence directly goes towards testimonial compulsion in this instance, Your Lordship. The Supreme Court further established in Bombay versus Khati Kalu that only physical evidences such as fingerprints, voice recordings, blood samples of the accused can go forward, can be claimed in this instance. The respondents have further gone to mention that we are not an official accused, hence the protection of 20 clause 3 is not against us. But the state of the Supreme Court in Xavier and others versus the state of Karnataka established that the protection goes forwards to suspects also. And the basis of them conducting the investigation was the internal suspicion notes of the CCID that our company was involved in the fraud, which is still yet to be proven by the respondents. Further, Section 69 of the IT Act, which authorizes interception and monitoring of electronic records, requires a written order from a competent authority in lieu of a warrant. In lieu of a warrant or any prior order, the authority which is conducting the seizure needs a written order from the state or central government from the position not less than a joint secretary. No such order was present in the first place. The sanction of law which they are claiming that they had the power to conduct the warrant in itself is not present from the very beginning. Then I will be addressing the restraints the restraints fail the proportionality test and violates procedural fairness requirements. The court in Modern Dental College and Research Center versus the state of Madhya Pradesh held that any restriction on a fundamental right under 19 clause 1 must satisfy the 4 states proportionality test, which was further upheld in Akshay and Patel versus the Reserve Bank of India. The measure must pursue a legitimate aim. The continued withholding of the mirrored systems after it has been recorded and copied by the respondents. Further, the fact that the respondents have not given any proof or any clarity to the petitioners on why they are being subjected to such arbitrariness. Second, there must be a rational connection between the measure and the aim. In this instance, if the respondents suspected the petitioners for the fraud, what could they have done? They could have taken the systems which were working for the bank alone, but no, they instead went ahead to clone and seize the entire procedural proceedings and data sets which we had to other customers also. This clearly constrained that the least restrictive method was available to them from the very beginning, which was not followed by them. Third, there should be no, apologies, Your Lordship, and the burden imposed must not be disproportionate to the aim pursued. In this instant, since for the last 2 years we have not had access to any of our systems, we are at a standstill. Further, we are in violation of the DPDP Act as data processors and fiduciaries to our other customers in this instance. Your Lordship, I would like to bring forward to the court that the Justice K.S. Puttuswamy versus the Union of India established privacy as a fundamental right under Articles 14, 19 and 21 and identified that data minimization and purpose limitations are the core principles of informational policy. Shreya Singhal versus the Union of India reinforced this by mandating procedural safeguards for digital restrictions. Vague, unstructured IT Act powers create a very bad precedent for legitimate operations. Further, the court in Anuradha Bhashan versus the Union of India stated that any restriction on a fundamental right needs to be followed by a written order, needs to be followed by a legitimate aim, and needs to be disclosed should not extend the period of time after which it is not necessary. In this instance, they had orally communicated to us that it is at a critical stage and continue to issue summons under the threat of coercion. And there was no written order from the very beginning for them to restrict the fundamental rights. The petitioners recognize that there can be certain restrictions which the state can put on the fundamental rights which we have claimed, such as Article 19 Clause 1G. But the restrictions needs to meet the constitutional proportionalities which has been said. Unconstitutional and unprecedented restrictions cannot be held, and that is exactly why the petitioners have come under 226 before the High Court. Say as natural when the court might say or the respondents might claim that there has been a delay, but the petitioners have cooperated to the level possible with the respondents. We have audio altered partum. We have given our pleas to the respondents that the metadata stamps show activity after seizure, but those were not listened to the respondents and they continued with their investigation. and continued with their investigation. And even if there was a 2-year delay, at the current moment the petitioners stand in front of the Honorable High Court, our fundamental rights are still in violation. They have been in violation for 2 years, yes, but at the current moment where we are asking the Honorable Court for relief, it is still in violation. Neuralink's data includes personal financial information from third-party banking customers. Investigative directions granting unrestricted access without role-based controls, audit trails, judicial oversight or necessary limits violate Puttaswamy's data. The respondents in this instance have shown complete disregard to constitutional safety. The respondents might claim that in public interest, for a scale of an issue where 120 crores has been a fraud has conducted in 5 states. Well, for the first point, there should be reasonable suspicion. The data which was provided to the petitioners in the first place was pseudonymized. We never had access to raw data. And the petitioners were working in a third-party API environment, as your Honorable Lordship stated, is the gateway to everything. They were working on a third-party API environment which the bank had directed us to use. We were now using our own environments. And our environments which we were using to safeguard the data of other customers has also been seized and not allowed access for the past 2 years by the respondents. And in light of all of this, the counsel for the petitioner would like to move forward to their prayer, where the petitioners pray to this court by the writ of certiorari, showing that the natural justice and fundamental rights of the petitioners have been violated, to quash the investigative proceedings which are being followed unregulated. If any new investigation is supposed to be followed, it must be done under judicial scrutiny and not under the blatant and vague statement of national economic security. And we pray the court to grant the relief and to restore the fundamental rights of the petitioners in regard to following their business and allow us access to the mirror systems to carry on our business and any other such release which this Honorable Court might deem appropriate for us. Thank you, Your Lordships.
Document the clubbing of issues. Since there have been 10 issues for your lordship's convenience and due to pauses of time, we have combined them. Much obliged, your lordship. Your lordship, the council seeks permission to your lordship, the council for the respondent seeks permission to approach the dais.
Yes, of course. You don't need permission. You always have to.
Much obliged, your lordship. May it please the court, my team code is TL13. The counsel for the respondent in the present case of Arjun Mehra and another versus Union of Aurelia and others. Your lordships, the counsel for the respondent will specifically be dealing with the combined issues 1 and 2, while my co-counsel will be dealing with the combined issues 3 and 4. If your lordships are satisfied with the facts of the case, may I proceed with the first issue?
Yes.
May I recite the first issue, or may I just proceed? Yes. Much obliged, your lordship. And may it please the court should not be concerned with the sower, but the harvest. This is the distillation of the logic in the case of Puran Mal versus Director of Inspection, AIR 1974 SC 348. Therefore, we respectfully submit that this warrantless search, seizure, forensic imaging and retention of the petitioner's digital ecosystem are lawful, justified and in consonance with the procedure established under law under Articles 14 and 21 of the Constitution of Aurelia. My lordships, this present case arises from a massive large-scale cyber fraud. There has been a fraud of rupees 120 crores. And there has been systemic and algorithmic compromise of data within the banking infrastructure. In this case, the authorities should not remain passive. They should proactively act swiftly, especially since there is digital evidence involved in this case, which, as you may know, is liable to be mishandled or even manipulated
if not seized within a short period of time. Therefore, we derive clear statutory authority from Section 78 and 80 of the Information Technology Act 2000, read with Section 185 of the Bharatiya Nagrik Suraksha Sanhita 2023. Section 78 independently authorizes the investigation of cyber offences by officers not below the rank of inspector, while Section 80 permits a warrantless search where there exists a reason to believe that an offence has been committed.
So warrantless search is an exception to the general rule that you need a warrant. And it took you 2 years to even, you have not yet been able to file a charge sheet. So does this delay justify a warrantless search?
Your Lordship, you must understand the nature of cybercrime and data itself. This is not a traditional search and seizure of a premises only. We are appreciating digital evidence which is inherently contained within there is a borderless structure. It is such on a massive scale that...
Counsel, let me interject at this moment. I totally agree with you that the quantum is huge, and you have to, because it's digital in nature, you will have to immediately intervene. I agree with you. But what have you done? What have you done? You have not. How do you establish accuracy when you have no hashtag? You know what is the nature of the hashtag? What happens? How would you establish that what you have cloned, what you have imaged, what you have copied is exactly what you are producing?
Your Lordships, we have provided the hashtag.
Does the statute provide you any guidelines as to how and what you do and whether you have done it?
Yes, Your Lordship, this statute is the section that I'm reading out. It doesn't specifically mention that we have to give these hash values. In fact, I would like to point out that this claim they are making that the hash values are mismatching is only on the basis of an independent expert that they have engaged. And this independent investigator has carried out an analysis of a very limited scope. We call into question the validity of his contentions. In fact, they have not even attained any certificate mandated by...
Counsel, argumentatively, even if I consider, we are not going to the expert. I'm just going into the technology that is very much and the IT Act. Considering that, how do you establish that what you have imaged is what you are producing? If you cannot, what happens with the hashtag? So you take something, before that you hashtag, and after that you hashtag. That is how you image. So if, from a technology perspective, now if you have not hashtag, if you do not have independent witnesses, and then tomorrow there is a passage, it is manipulated, how will you establish?
Your Lordships, if you could please turn to page 4, under part 3 specifically of the Statement of Facts.
Go ahead.
Yes, if you could please turn to it, Your Lordship.
Please.
It specifically says on the 17th of September 2024, we provided hash values through an email.
When was the seizure done?
It was done only 3 days prior.
So in these 3 days, how do you establish it is the same? It's you yourself said that just within the second things. I mean, you didn't say the second. You said that because of the digital nature, it can be manipulated. So immediately we have to seize. If you have to seize because it is of digital nature, then later on, how do you sit on that for 3 days?
Sir, we have not even sat on that for 3 days. We have required these 3 days to comprehensively image and analysis. Additionally, we would like to contend that such a matter
it's already done. Now at this moment, how do you want to rectify? Is it possible to rectify? How do you rectify under the IT Act and under the DPDP Act?
Your Lordship, there is no need to rectify. We have complied with the requirements of the Act. We have provided the hash values in the email. We have done it after 3 days. And we have done it through an email.
Very basic question is, when you have a search and seizure without a warrant, you still need independent witnesses. So you don't have, there is no independent witness. Secondly, the person from whose custody you are seizing the material has to affix his or her signature on the seizure list. That was not done. So what you have sent 3 days after the seizure, how is that admissible in evidence? How will you corroborate that with independent witnesses?
Your Lordship, additionally, firstly, they are silent on the fact of an independent witness itself and the facts, but the email itself has evidentiary value under Section 3, 4 and 5 of the Information Technology Act 2000. It validates the legality of digital evidence as well as a digital signature. How can you see that we haven't affixed any digital signature itself to the email?
What does BNSS 63 say? That is 65 of, what does it say? Where is the certification? Where is the certification? What, if you go back to jurisprudence, and if you go back to, yes, and if you, yeah, where,
yes.
What do you do for digital evidence? What is the observation? What is the ruling of the Supreme Court?
My Lordship,
in Arjun Pandit Rao.
My Lordship, I must tell you that such facts and the admissibility of evidence itself is factual, and this must be decided by the
factual. Sorry, counsel. You have a typed memo. You have a typed inventory. How do you produce it in digital form? You have not. How do you access digital? It's a typed. Did you scan it? Did you make it machine readable? You have not.
No.
So every step, if you talk about the IT Act, every step you have flawed.
No, Your Lordship. Such evidence itself in its digital form under the aforementioned section that I mentioned will be considered good in law. In fact, it is primary evidence as per the amendments made to the Bharatiya Saksha Adhiniyam. In fact, such matters should not be dealt with by the Honorable High Court. In the Honorable High Court, when we come to the writ court, we are arguing on the points of law. We are not judging the admissibility of evidence.
We are entirely on Article 14 and 21. These are the 2 articles on which they base their arguments.
Yes.
14 is, they have said it is unreasonable, restraint, because you have stopped their business completely. 21 because, very basic, those other things which they have said we can ignore. 21 because the right to continue their business is a fundamental right which you have stopped. The other thing is that you have taken data of third parties without any authorization by law. Apart from the banks, the whatever system they use for the bank, you have also have access to third party data because you force them to give their encryption password. And giving encryption password means you have access to everything, right? So will that not offend the Data Protection Act and also their right to information privacy, which Puttuswamy has upheld?
Your Lordships, Your Ladyship, I would like to remind you that under Article 19 Clause 6, there are reasonable restrictions put on the right to freedom of trade and business. They have committed such a massive, we haven't even accused them of this fraud, but
that is why. You have not accused them, but you have presumed that they have committed and taken away their business, stopped everything, taken away third party data on the suspicion that they may be a part, but you still don't have, there is no arrest, there is no charge sheet. Investigation is still not complete, so why can't they start their business?
Your Ladyship.
Also, only one thing, can the reasons to believe substitute the suspicion?
Your Ladyship, let me substantiate with this case. We have a reason to believe under, and this is allowed by Section 80 of the Information Technology Act as well as Section 185.
Is it necessary to be recorded? Is it necessary to be recorded? Reasons to believe? Or you can think of that I have reasons to believe I can act?
under section 80, it doesn't say recorded reason to believe, it says reason to believe. In fact, in state of Maharashtra versus Bharat
It
Shantilal,
is challenged in a court of law. Don't you need to substantiate that?
I am substantiating it, Your Lordship.
Did you include them in the FIR? FIR was against third parties, unknown persons. You have continued to investigate for 2 years. You have stopped their business. You have taken away the relevant data at that point of time. Subsequent data has nothing to do with what the data that was collected at the time of offense. We understand that that urgency was there. For the sake of, you didn't want to take the risk of data destruction, or the nature of digital evidence is ephemeral, so you proceeded without a warrant. Till then we understand. Have you included them as an accused?
Your Ladyship, we have reason to believe, and this is very strong reason to believe, and in fact this is itself enough for the search and seizure, because they themselves were the data processor.
Search and seizure is over. We are now on the next step, whether they can start their business and whether they should open up, because they are also they cater to third parties who are not involved in this issue at all. So why can't they regain their business and commence their work, and trial will follow if you ultimately are successful in filing a charge sheet?
Your Ladyship, firstly in the facts it is
They are still not an accused, as you said. So if they are not an accused, and you have all the relevant data and evidence with you, why can't they resume their business, and why this unlawful restraint?
Your Ladyship, it is not an unlawful restraint. We have done it in the interest of the economic stability of Aurelia. For example, if you appreciate the case of Bank of Baroda, which is not similar, but it is a case again involving a massive fraud. You will see that this fraud of even one bank or one bank can have large cascading consequences, and there is already the vast scope of digital evidence in this case. We have not curtailed the right to freedom of business. We are only ensuring the national stability of the Union of Aurelia. And further, we are still at the investigation stage. And not only that, Your Lordship, this case has come just for final adjudication. If you appreciate the facts of the case, this is just the final adjudication of the case. Meanwhile, we have not been able to continue our investigation because of this proceeding. In fact, they have resorted to forum shopping. This should not have been taken to the writ court in the first instance. These are facts that must be appreciated by the trial court itself, Your Ladyship.
We are not on the facts. We are not even interested to know what you have and whether you have a right to proceed against them. What we are saying is that since you have taken the time that you have taken, and they are not an accused, you have not found any incriminating material to include their name in the FIR. You have not yet completed the investigation is going on. So if you balance equities, this is like the Court of Equity 2022-26,
Your Ladyship,
should not they be allowed to continue their business?
Your Ladyship, can you please turn to page 4 of the facts of the case, paragraph 10.
Please read out, please.
10, paragraph 10. In October 2024, the petitioners were already informed that the forensic examination had revealed incriminating log patterns indicating possible data exploitation linked to Neuralink software architecture.
So what's the problem? You have seized, you have their soft data, you have their hardware, you have everything. And for 2 years, you're continuing, that the nature of the technology is such, everything is moving. Now, why should they not be moving with the business? That's why they have come here. You're saying they should not have come here. They have gone, after 2 years, they say that my right, it's a matter of equity, as Lordship has mentioned. Why do you want to restrain them from their rightful employment or business or whatever? That's the point. And from a technical perspective also, you do not have a case. I'm not going into that, but even then, you have not, procedurally, you have not considered.
procedurally we have a case. Even independently we can pursue.
Let's talk about the others. I mean, we have dealt with. We don't go back. You lose time. Let's talk about the argument that just now we are talking about.
Yes, we have not restricted the right to trade in business, Your Lordship, merely because we want to. It is because we are in the interest of natural justice we have done this. There is such a massive fraud at a massive scale that it has impacted the public. This Aurelia First Bank is in fact a massive scheduled bank regulated by the RBI Act 1934. It is of an institution that is of great importance, that has impacts on the public. If we don't protect the public itself, then that itself will violate the constitution. That violates the due process established under law. If we did not investigate, it would have been a grave failure on our part. We have failed this nation.
Counsel, no one is saying that you don't investigate. You are deviating from the issue that is on being adjudicated.
We have retained their assets in order to ensure this complete justice, and that all facts of the case the facts of the case and the veracity of the claims made against them. There is such a severe due to the nature of the case. Additionally, there is a possibility of them continuing this fraud if we had not seized these assets. Do you expect that if they have committed a fraud once, they may not do it again?
So on the basis of a suspicion, a remote suspicion, when you do not have any evidence to even arrest them or detain them or even name them in the FIR by accusing them, you think that they will, in a presumption or a speculative manner, you will put them out of business for years together?
Your Ladyship, it is not merely speculation. I would like to cite the case of State of Maharashtra versus Bharat Shantilal Shah, 2008-13 SCC 5. If you could please turn to page 10 of our compendium.
Yes.
If you want to refer to our memorial, it is at page 8, paragraph 1.1.2. But in the compendium, it is page 10. Yes. The Honorable Supreme Court held that the reason to believe denotes an honest inference drawn from the material available at the time. It's not conclusive proof, but in the present case, this 120 crore fraud and the bank's finding of system-level manipulation and the petitioner's direct involvement in the processing of this transaction data together constitute sufficient material to justify such belief. Yes, with these 2 more minutes, may I move on to the allegations they have made that we have coerced them? It's amounts to coercion under Article 20(3). The petitioner's allegation of coercion that we have made them a witness against themselves is further also misplaced. We have only asked them for passwords and credentials and access keys. We have not compelled them on the basis of their personal knowledge, as clearly laid down in the case of State of Bombay versus Kathikalu Oghat, AIR 1961 SC 1808, where the Honorable Supreme Court held that this protection only applies to the psychological and personal knowledge. This is in fact affirmed by the case of Selvi that they have mentioned. For example, I would like to ask the opposite party if they remember their own passwords. Do they remember all of their own passwords? Or do I or any of us remember all of our own passwords? No. It is not psychological. It is only a physical act of giving evidence.
If you are asked for your password, you use your brains to think and ponder and try to remember. Isn't that something which has a psychological impact?
No, Your Lordship, especially in such cases, these passwords must be physical. You cannot expect someone to remember such an important passkey. This is just a physical act.
Counsel, what is your argument?
My argument argument that this is not compulsion, there is no psychological element of compulsion to be a witness. We have further not coerced them through the summons that they have alleged in page 4, paragraph 13. The summons were duly issued under section 179 of the Bharatiya Nagrik Suraksha Sanhita. It permits the attendance of person acquainted with the facts of the case, and they were present during her search and seizure in fact. In fact, the Honorable Supreme Court in Nandini Satpathy versus Pierre Dani, AIR 1978, SC 1025, if you could please turn to page 16 of the compendium.
So they get the extra time that they have.
If you could please turn to that page 16 of the compendium.
Yes.
You'll see that, you will appreciate that the court clarified that lawful questioning and requirement of cooperation do not amount to compulsion unless it is accompanied by force, threat, duress, and none of these have been demonstrated in the present case. Our case is based on a clear and rational foundation, satisfying the constitutional requirement of non-arbitrariness. We have a legitimate aim, we have legality, as I have stated, and we therefore have a rational nexus that in order to ensure procedure established under law, we must investigate them as allowed by the provisions of the Information Technology Act and Bharatiya Nagrik Suraksha Sanhita. If your lordships are satisfied with the facts of the case, may my co-counsel deal with the third and fourth issues. The counsel seeks permission to dissent from the dais.
Yes. Your lordships, may the counsel approach the dais. Much obliged, your lordships.
Your lordships, I request you to picture this. In the shadowy world of codes and clouds, evidence does not stroll away. It vanishes with one single click. When rupees 120 crores drain from our banking system, we do not ask why the CCID moved so swiftly. Rather, we ask what catastrophe unfolds if it didn't. Your lordships, with your due permission, the council shall address issue 3 and issue 4 of the case.
Yes.
Much obliged, your lordships. The petitioners say in this written submissions, your lordship, that private premises of the Neuralink and hence section 80 of the Information Technology Act 2000 is violated. Therefore, everything falls. But our respectful answer to this is section 80 does permit what was done, but only because we satisfied every constitutional and statutory guardrail that makes such an entry an exception and not the rule. Your lordships, the petitioners have built their attack on one single phrase, that is public space, as if it was a brick wall between law and the reality. Clearly, your lordships, cybercrime does not respect this wall. Servers in the secure offices, laptops in boardrooms, cloud consoles in private spaces. That is where a rupees 120 crores fraud lives in. We clearly abided by section 80 of the Information Act 2000, which gives a police officer above the rank of an inspector the power to conduct search and seizure without a warrant. This section, when read with section 78 of the IT Act 2000 and 185 of the BNSS, your lordships, because clearly section 80 is not a standalone provision. We need to club this very provision of the provision with that of the BNSS and the other provisions of IT Act to extract the true meaning and essence of the objectives that the letter of law mandates. Your lordships, moving further, if the law were frozen at the door of a glass building simply because it is private, every serious cyber crime would enjoy a built-in sanction. That is not and has never been the jurisprudence of the court of law, your lordships. Supreme Court judges like Justice P.N. Sri Krishna, Justice Suryakant and Justice Prakash Mishra have time and again reiterated that cybercrime is technical and often occurs within the complex systems called.
Counsel, sorry to interject. I don't think anyone will deny what you're saying. Cybercrime is important. The issue here before us is not whether cybercrime is important or not. Maybe the petitioners have not talked about that. As Lordship has already mentioned, the Court of Equity. So let's talk about that.
Your Lordships, they have mentioned it in their written submissions. So that is the reason I wanted to clarify this point. Because cyberspace is borderless, Your Lordship. And here we are not talking on the traditional crimes that are taking place in the country. We are talking about the borderless crimes.
Yes, Your Counsel. Sorry. In the sense, exactly that. You have intervened and you have seized documents, software, hardware. It's a question of whether you have followed due process, and without that, whether you are actually breaching their fundamental rights and also the fundamental right to carry on their business. So this is the issue. It's not a question of whether you should act immediately or not. It is appreciated that you have acted immediately. But then, what's about the rest?
Your Lordships, here the CCID had a positive obligation towards to safeguard the rights of the people of the country of Aurelia and act in their financial interest for the greater public good, and that is what they did. In such a case where CCID was investigating such a huge fraud, it cannot allow such breaches to happen, Your Lordship. It cannot allow the company to function at such a crucial stage of investigation. Even freedom of trade is not absolute and has restrictions under Article 19, Clause 6 of the Constitution of Aurelia. And the CCID tried to keep the interest of the public good and welfare along with the financial interests of the people at the foremost. Thus, today we are arguing on before the honorable bench whether the question here is whether the right to trade and earn profits of a private company is of greater importance or financial interest than that of the people of Aurelia. Here we are arguing for the people of Aurelia. The CCID had conducted all its investigation, the investigation is still going on, Your Lordship, and they are conducting it for the people who have lost their money. It is not some random theft. It is a huge amount of breach. And Your Lordship, I would like to recall the 2008 recession or the Great Recession. With the Lordship's due permission, I would like to present an article and a research paper for clarification. Your Lordships, this case has shown us that the fall of even one single institution can have major long-lasting shocks on the entire economy of a country and may even have global impacts. US was criticized for this particular recession for a very long period of time, and this happened due to one single enterprise. That was Lehman Brothers. And here we see a similar case, Your Lordship. Also, Your Lordship, in a developing country like Aurelia, which is a powerhouse.
Counsel, sorry to interject. This is an article.
Yes.
This is an article. Fine. And as already mentioned, there is no doubt about the impact of a 120 crores fraud. There's no doubt there's impact on the public, those who have put the money there. We are not talking about that. We are talking about the petitioners' prayers and the point of law. And it's a question of equity, balance and proportionality. Let's talk about that.
Your
This is
Lordship,
fine, but I'm not into this.
Your Lordships, regarding the threefold proportionality test that you just mentioned, the council, my learned Crown Council needs to understand that 120 crores breach is the legitimate aim for the
Quantum of the amount, the quantum of cyber fraud, the money, how will you suppose it with the rights under Article 14 and 21? Even if it is 10 rupees, it can be a cyber fraud. But the point is that how is the 120 crore relevant when it comes to depriving a citizen of Articles 14 and 21 of the Constitution of India? And you have already finished your search and seizure, you have done your part. Why, even if we do not allow prayer A, that declaring that the search and seizure is back, because there is another forum where they can take up that issue if the situation so arises and there is a trial. But why cannot they resume their business?
Your Lordship, that is because, to answer your first question, if it was a rupees 10 fraud, rupees 10 cyber fraud, it would not have been presented before this Honorable High Court due to pecuniary jurisdiction. Just because...
No.
26 does not have any pecuniary jurisdiction.
We are in read court.
226 do not have any pecuniary jurisdiction.
But,
so any value can be challenged before the High Court.
But it would not be presented before the Honorable High Court if it was a matter of rupees, less than rupees 10,000.
Here the Article 226 of the Constitution of India is for enforcement of a fundamental right or a legal right or a statutory right. This is they have invoked the power of judicial review under Article 226, alleging the illegalities and irregularities in the procedure adopted by you, in the investigation that you have done, the way you have conducted the investigation, and lastly because of putting a fetter on their right to continue their business.
Or in the other way, whether the steps which you have taken can be said to be procedures established by law.
Your Lordships, we have complied with all the procedures established by law, and just to rectify one mistake that had been made by my co-counsel, we do hold them as accused. Otherwise, we wouldn't have. We do hold them as accused because they were the only third party, or say the only data processors that Aurelia First Bank had. And
have you incorporated their name in the FIR?
No, Your Lordship.
Then how can you hold them as an accused?
We have, and that is why, because we got incriminated.
Yes, alright, you can hold them. Of course, you can hold them. Investigating agency can always do that. But till now, at 2 years, you have not held them and found them to be an accused. But otherwise, you would have incorporated their name in the FIR. FIR was unknown persons.
Your Lordship, this matter was in the very first instance of this matter. We see that there was a third-party inference, and that is why this entire data breach happened. Secondly, the CCID had also, after they suspected that it might be from their end, after conducting the search and seizure, they found incriminating log patterns as well. And Your Lordship, they had, after this, when we had seized their items, whatever we procured from the evidences, we had seized it so that this breach does not continue.
Why have you seized it? What is the intent of seizure?
Your Lordship, to look into the intricacies. And look...
How? How will you look into the intricacies? You have seized something. Will you sit down in your home with that? What will you do with that?
Certainly, Your Lordship, we wouldn't. But...
No, what will you do with that?
We would dig deep into it.
No, you're not still getting me. You will dig deep. What is that of value to you as CCID? I seize the software, hardware, documentation, administrative documents, everything. What do I do with that?
To determine...
Where? Before which forum?
Your Lordship, we are still investigating. And once it is done, we'll present it to the trial court magistrate.
So, exactly. Then how do you produce? There's an issue of admissibility. I don't want to bring this. Even if on the procedural side you said there is no procedural lapse, there are procedural lapse. There's no certification. You have not, whatever you have picked up, you have not, whatever soft data that you have picked up, you have not hashtagged. You have not followed the Evidence Act. You have not had an independent witness. You have not kept an independent witness. When you have seized, you have not got it signed. After that, if you look into the IT Act, you have not done that. After that, when you want to produce, you have typed it. When you have typed it, you have not produced it in a soft manner. It is not scannable. It is not accessible with the computers. So many procedural issues. After that, you have not approached us saying that I can bring the one who has signed and produce him on oath to say that this is genuine. After that, you have not or an expert to say this is genuine. There's a 3 days that the entire digital data cannot be admissible under statutory requirements. One after the other. How do you argue against it?
Even to address this question, even if there were minor procedural irregularities, in the case of H.N. Rishabut versus State of Delhi, could your lordships please refer to page 456 of the compendium wherein we have mentioned it. And also in the case of Prakash P. Hinduja and Dr. Naresh Kumar Garg case also, all these cases, your lordships, affirm that investigation irregularities do not nullify the proceedings. They influence how a trial court weighs the evidence.
Indeed. I'm very happy that you mentioned. How do you rectify it? Tell me.
The procedural irregularities?
Whatever. I have listed so many irregularities. Now at this moment, how do you, let me see how you rectify. Is it possible to rectify? Maybe it is. How?
Your lordships, that will be done by CCID if the trial court mentions so. Of course,
court doesn't mention. If there are irregularities in your investigation or you find that your evidence, the quality of evidence, there is a discrepancy in the evidence or the way you have collected the evidence, and then how do you rectify that to make it admissible?
Your lordships, as I said, it is admissible because the courts have already stated in various judgments that minor
is admissible, but it is admissible provided that
what?
How?
Provided be rectified.
Okay. Proceed.
All right.
Your lordships, moving further, the breadth of seizure and mirroring is justified by the nature of digital evidence and selecting imaging risks, missing or contaminating interlinked data in a complex system. Hence, capturing digital ecosystem is the most proportionate way that we could preserve the integrity. As per section 79A of the IT Act 2000. In short, your lordships, this is not the face of an unrestrained state. It is the face of state using strong powers in a hard case under judicially recognizable safeguards only. Your lordships, if you're satisfied with the third issue, may I please proceed with the fourth? Much obliged, your lordships. The petitioners herein ask whether this honourable court to take one hard case and rewrite the investigative code of all the cybercrime cases. But Article 226 and 227 have always been used with caution around live investigations. Your lordships, in CBI versus Rajesh Gandhi, 1997, 1 SCC 27 and Mohammad Yusuf versus Afaq Jahan, 1 SCC 627, it was reiterated that decisions on who investigate and how to who to investigate and how to investigate fall within the executive autonomy, with the trial court as the primary forum to test legality and reliability. Here, there is a formal FIR regarding a massive system-level fraud, recorded reasons supporting urgency and search without warrant under Section 185 of the BNSS 2023. Your Lordships, and thirdly, a direct technological and contractual link between Eurolink system and the compromised infrastructure. Your Lordships, hence, the Constitution expects the court of law to be a shield against abuse, not a daily supervisor of investigative judgment. The correct place to contest this hash integrity, chain of custody, scope of mirroring, all the procedural irregularities is the trial court. And no one is stopping them from and not stopping us from investigating this case right now. Your Lordships, with this, I would like to present before you a case of Ms. Niharika Infrastructure Private Limited versus State of Maharashtra and others 2021. Shall I please? Your Lordships, as supported by the case of Niharika Infrastructure Private Limited versus State of Maharashtra and others 2021 19 SCC 401, the impute writ proceedings are liable to be quashed. This is a matter of the Honorable Trial Court and not the Honorable High Court. The petitioners have clearly resorted to forum shopping, Your Lordships, wherein a party chooses or tries to choose the most favorable court or jurisdiction to file a case instead of going to the most appropriate one. If Your Lordships are satisfied with my fourth issue, may the Council seek 30 minutes to conclude with the prayer, 30 seconds to conclude with the prayer. In light of the facts and circumstances of the present case and the submissions advanced herein, it is most respectfully prayed that this Honorable High Court may be pleased to dismiss the present writ petition as being devoid of merit, hold the actions of the respondents lawful, justified, and in consonance with procedure established by law. Uphold the validity of the warrantless search, seizure, forensic imaging, and retention of the petitioners' digital devices and cloud repositories as a necessary and proportionate exercise. Declare that the disclosure of encryption keys, credentials, access tokens does not amount to testimonial compulsion. Hold that the ongoing investigation is based on reasonable suspicion supported by material facts and does not suffer from arbitrariness under Article 14. Direct that issues pertaining to evidentiary integrity be adjudicated at the stage of trial and not in the writ jurisdiction. Uphold the limited restraint on access to mirror systems on a reasonable restriction. Recognize that considerations of national economic security and urgency in cybercrime investigation justify a measured relaxation of procedural safeguards. Refrain from exercising writ jurisdiction in a manner that interferes with an ongoing investigation. Pass any order or orders as the Honorable Court may deem fit and proper in the interest of justice, equity, and good conscience. And for this act of kindness, the respondents shall ever be played duty bound. The Council seeks permission to leave the dais. Much obliged, Your Lordships.
Participants can move ahead with the rebuttal, but as paucity of time, we have a paucity of time. We only have 5 minutes for rebuttal. Yes. Yes, please.
obliged. Your Lordships, I'll be raising 3 rebuttals very shortly. First one would be that they claim urgency as a getaway to jump over provisions. If it was so urgent, why did they sit on it for 6 weeks plus 2 years? 6 weeks is enough of a time to gather an ex parte order from the magistrate and approach us. They could have done it in the morning, showed up at our doorstep in the afternoon. We would have not had the time to delete a layered AI infrastructure. Secondly, we have repeatedly asked for certification and other conclusive proof from the respondents to show that we are the defendant of laws. They have not provided with it and have also claimed that we have done it under limited circumstances. The newly expert engaged under limited circumstances. We didn't have the time, nor did we have the material engaged by them. Thirdly, furthermore, in Dwarkanath, the judiciary can intervene at any action which it feels that is unconstitutional, not just actions by the administration but also by the executives. Firstly, my learned co-counsel said that we have quoted our office to be a private place. By their rationale, any office, any law firm, any company would be considered a public place, and anybody can move in and out of it. But that is not the case. And lastly, Your Lordship, there is a major mistrust against the state at this point in the minds of the petitioners. Firstly, they have stopped our business for 2 years. Secondly, we have also prayed to this court we have no problem with the respondents continuing the investigation. We pray to the court to let the procedure continue given the evidence collected through procedural lapse is not submitted. My rebuttals and much obliged.
Your Lordship, the respondents in this case have stated, firstly, that the legitimate aim for them to come ahead and access our environments was because 120 crore fraud exists within our servers. Well, within 2 years, they have not been able to establish that. Secondly, they say that we were just asked to compel the disclosure of passwords, whereas they were under the threat of coercive detention, under the threat of immediate detention, they have asked us to diverge it. It is not a passive action, it is an active action. And since the learned counsel sought to refer to us a written submission, I would like to point out in the respondent's written submission on page 19, they have cited Shafiq Mohammed versus the state of Himachal Pradesh to establish that evidentiary lapses in the procedure is not affecting the evidence. This very case has been overruled by the Honorable Supreme Court in Arjun Pandit Rao to say that the procedural lapses cannot be accepted by the Honorable Court. Further, they have stated state of Maharashtra versus Bharat Saninlal Shah. They operated, in that very case, the state agency operated on a specific Maharashtra Control Organization Crime Act, which was for organized crime, nowhere relating to us. Further, they have gone to mention Nandini Satyapi, which Nandini Satyapi says apologies, Your Lordship. Upholds Article 23 and applies Article 23 to the stage of protection where apprehensible prosecution is reasonable prosecution is apprehendable by the petitioners. In this case, it clearly was. Further, they have claimed that they have orally submitted all the necessary information, but when a continuing restraint on a fundamental right is there, oral orders are not valid. And further, they have stated that the respondents have failed to address the very core of the petitioner's prayer, that our fundamental rights are continuously being violated, not just the limited right of Article 19(1). Whose restrictions are also not meeting the constitutional right, but the absolute fundamental rights of 14 and 21, which has blatantly been violated by them. Thank you, Your Honor.
Council 6 years. Much obliged, Your Lordships. First,
Your Lordships, may I begin? Much obliged, Your Lordships. Firstly, Your Lordships, I had stated during my oral submissions that the respondents, especially the CCI, had a much greater obligation, and when the economic stability is in question or is in is endangered. Article 14 and Article 21 of just one of the petitioners are being questioned. What about the people who have lost their money? The 120 crores breach is there. The people from 5 states, Your Lordships, they have lost their money. What about them? Aren't they subject to these fundamental rights? Your Lordships, and also the petitioners have said that we did not address their the prayer, whereas we did. And Your Lordships, they have also mentioned the case of DK Basu, which my co-counsel will further address.
Before I do, I need to deal with the accusation of we have wrongfully searched a private company. In this case, we admit Section 80 of the Information Technology Act allows for warrantless search in a public place. However, we contend that since Aurelia First Bank is a bank that carries out a public function necessary to society, it shall fall under Article 20, Article 12 of the Constitution of Aurelia, as held by the case of Rajasthan State Electricity Board, Jaipur versus Mohanlal and others. 1967 SEC Online SC 18, where it was held that the definition of other authorities can extend to private companies as long as they carry out a public function. And therefore, through their agreement with Aurelia First Bank, Neurolink itself will fall under this. Now, coming to the explanation of Section 80 of the Information Technology Act, if we apply the principle of adjutant generis, we will see that it is an inclusive definition. It says includes a shop, a hotel, and any other premises. Therefore, it is probable that such should be considered a public place and not a private place. Additionally, they have stated cases of traditional crimes. They have such as the NDPS Act or other cases. They have not referenced cases of cyber crime that deal with a special law, because special law will always prevail over general law. Will usually prevails over general law. In fact, we would also like to point out that they have mentioned the DK Basu case. However, DK Basu case, those guidelines were given on arrest. Those were not given on search and seizure. It is not relevant. Further, they have not been able to show you that there is any exception under the Digital Personal Data Protection Act that allows us, but we are allowed by that act. Under Section 17, the subsection 2, Clause A of the Act, we are allowed to investigate if there has been any breach in data. Further, they have mentioned the case of Shreya Singhal, but my lordships, I would like to contend that that case is not relevant at all to this case. That is a different fundamental right. That is the right to freedom of speech and expression that is being addressed in that case. It is not relevant to their claim of violation of the fundamental right to trade and business. Additionally, your lordship, we would like to contend that again, our case, it may have any procedural lapses, but as per the cases of Kate Singh versus Union of India, as well as State of Punjab, these irregularities are still allowed, even if it serves for the larger investigation and trial, which must be conducted on the basis of natural justice, your lordships. May I dissent from the dais?
I think I speak for all of us. And congratulations to both the teams. Excellent performance. I don't think even now we would have been able to put across the facts and the appreciation of the law, the citations that you have produced, the way you've analyzed the law, and the way you have used the law to put forward your arguments, and for both sides has been excellent. And having said that, and we are also very sorry to have bombarded you with questions, because that is something you have to actually learn. The readiness of a council, the capability of the council to think on her legs or his legs, to not get nervous by the court, by how the court questions you and keeps on questioning you, by knowing when to stop, by knowing when to address the court and take the question first, which both the teams has done remarkably. Because normally when we are sitting in the High Court and we ask a question, there's always a tendency of the counsel to deviate because he doesn't have an answer or is not ready with the answer or knows that that question is actually nailed the issue. I cannot persuade the judge otherwise. That is something which doesn't ever go well with a judge. Judges will always want the question that they ask to be answered. So I think you had a difficult case because, well, we all believe that here 21 and 14 has been violated. So then, of course, our marking has nothing to do with which is the better case. Our marking is entirely on how the counsel of the respective teams have come up with their issues, the appreciation of the facts, the way they have the poise, the gesture, the way, the demeanor is very important, and how they have assimilated the entire fact of the law and the synergy between the law and the fact, the relevant citations. So marking is not on the issue of that the judges felt that this is a good case under Article 226, but the judges have marked on your performance. Justice Bhattacharya wants to add?
Only one thing I must tell you. When you cite some judgments, you have to be very careful. Whether it has been overruled. And another thing is, don't cite too many judgments. Because 1 or 2 points may be in your favor, but the majority may be against you. So be careful in citing a judgment. Please check before citing whether it has been overruled or not. That's very important. Now we have not judged which party will win the case. We have only judged your performances. So all of you have done really very well. You have answered the queries. You have kept your cool. That's important. And you have, in your own way, you have tried to answer the queries of the bench. Thank you.
Thank you very much. So not to repeat what has already been said, but definitely picking up from what Justice Bhattacharya has just mentioned, that the one which was overruled was already referred by me. Already I referred to that. But you because of the tension or perhaps you missed it out and you went back to and you mentioned that. So this is very glaring. That's one thing. The other thing which I would definitely like to point out is, do not see the bench as your adversary. Even when the bench is questioning you, we are giving you leads in the sense continuously saying, but you are in both the sides and not anyone specific. You're going all about not getting, in the sense I'm trying to feed you the issue even when you're not getting it. So you have to try to understand, and this will happen whether you go into litigation as a pleader or whether you go and do any other work as a lawyer. So that you can do many things. If you do not understand what the subject, the person with whom you are communicating, what he or she wants, then you are lost in sort of lost in transition. So that should not happen.
You should move with the bench. Exactly. That is the first quality of advocacy. You should flow with the flow of the bench. Because, see, the moment the bench feels that you are trying to deviate or trying to take a different path and the bench keeps telling you to come back, may not be correct, we may be wrong. We may be absolutely wrong and you may be absolutely right, but that is where the skill of advocacy lies. To calm down, take a step back, understand what the judge wants. You have to feed the ego of the judge, let us put it back as simply as that. I mean, that is the important part.
Because 1 point, a question from the bench may be against you. Maybe the bench is hurting you on your weak point. So you have to give answers. You cannot say, no, I will not give answers. You have to give your answers in your own way. Then try to put forward your best case. Because 1 or 2 points may be against you, may have some weak points, but you have to somehow manage those points, but you cannot say, no, I will not answer. So you have to give answers in your own way. Then you have to come straight away to your strongest points and make up your case. So that's important, which you have to keep in mind. It's a good thing because when we were in your position, we did not have any opportunity to participate in this. So our first moot court was before the judge. So now, so you are getting these opportunities. Please avail of those opportunities. I think that will help you in your future. Thank you. Best wishes to all of you.
If you are nervous before approaching a bench, it's good. My hands used to become cold even the last day when I appeared before a court. So don't think that you have to be really, really smart and very, aggressive and very, confident. No. Humility is most important before a bench. You have to be extremely, extremely humble. And you have to understand, as I said, a judge who is sitting over there has an ego. I would not say an ego, a vanity, or don't quote us. But yes. So as I said, follow the judge, understand the sentiment of a judge, understand the expectation of a judge, and move with that. It is an art, you will learn. And you really don't need to be super confident and appear to be, very smart, and a judge doesn't really get impressed with all that. It is when you humbly ease your way into an argument. That is how it should be.
Don't raise your voice while arguing. Be cool. Don't raise your voice, because by raising voice you cannot improve your case.
And you don't ask the bench questions.
So,
would you like to know this? Would you like to do this? No. And there is no need for you to, that. If you are satisfied with the first issue, can we move on to the second issue? That is now, you're not supposed to know whether we are satisfied or not by asking us. You are supposed to do your best case. Move on. Alright? These are the basic tips which we can tell you. Mooting's principles may be a bit different, but in court, if any of you actually want to be litigating lawyers, which we really, really encourage, especially women, because if you see the ratio, it is much less, and there is a lot of...
No, nowadays, I will differ with Justice Sarkar. Now it's increasing.
Yes, it's
this
increasing.
gap is...
No, but the number of women coming to the profession may have increased.
But the percentage of entry nowadays, that has
increased. But the number of women who are seen by the bench, still there is a huge gap. And there is a lot of work, lot of research, lot of discussions at the international forum where we have made commitments to abide by. India has made those commitments to abide by those conventions, which includes equal representation of women in the bench and at the district level, at the high court level, in the high judiciary also. So we really encourage them. These are your college, your educational institution is giving you that platform to, these moot courts. All these competitions that you have, these are all grooming you. So I do not think you should really, please choose litigation as an important alternative, the most important option, because we need good people from good institutions to come up as lawyers.
Only litigation you can solve the society in a much better way than in any other service.
Your Lordships, maybe we can have another moot or discussion on that.
Yes. Thank you. Wish you all the best.
Thank you so much.